Good morning and welcome to the Court of Appeals. Before we get started, I want to introduce your panel for this morning. It will consist of Judge Arnold Golden from Memphis and Judge Kenny Armstrong from Memphis. I'm Steve Stafford from Dyersburg. We will follow the rules of appellate procedure as we conduct this oral argument. Each side will receive 15 minutes to make its oral argument. If you're the appellant and you wish to reserve rebuttal time, I assume you've already done that with Mr. Hibner, and you'll be given that rebuttal time. You may reserve up to 5 minutes of rebuttal time. Obviously, the appellee gets no rebuttal time. We appreciate you participating in this Zoom oral argument. It's something that I'd like to say is new and different, but we've been doing it for so long, I'm not sure it is. But we'd kind of like to get back to doing things the way we used to do them. But we can't do that until it's safe for everybody involved. And we want to point out how much we appreciate Mr. Hibner and his staff, as well as the AOC technology staff, for making this all possible. Mr. Hibner, anything we need to take up to get started?
No, Your Honor.
All right, you may call the case, please.
Dennis Williamson versus Regional One Health et al.
We'll hear from the appellant.
Thank you. This is Attorney Tootin from Shelby County on behalf of the appellant. I've reserved 5 minutes of rebuttal. This argument is a very straightforward argument. The facts, very simply, is that Mr. Williamson was having health issues. He's not sure what was wrong with him, was having issues with paralysis and falling over, lightheadedness, things of that nature. He ultimately went to the hospital. He had a spinal tap fluid done. He ultimately had to have an extra spinal tap fluid lumbar procedure done, a lumbar puncture to get the spinal fluid because a sample was lost. That's our contention. The opposing party's argument is that there was no sample that was ever lost, which is basically where the negligence of this case comes down. So the case was ultimately, it was dismissed and summary judgment was granted on behalf of the appellee because in part, there was no medical expert provided by the appellant at the trial court phase. So I want to start there because that's the crux of the case. This is indicated on page 7 of my brief, but when dealing with a healthcare provider, we understand we are under the medical malpractice law, or as it relates to the pre-suit notice and those steps. However, when fleshing out the heart and the facts of this case, appellate concluded that the issue with the lumbar puncture and the fluid being lost, which required an additional puncture, an additional fluid to be taken, we concluded that that is basically a common law negligence claim or a type of negligence claim where no expert is actually needed, meaning there won't be an expert to say you should never lose fluid that's supposed to be stored for testing. That's something that on its face we realize is a negligent action. And we quote law that clearly says that the general requirement is for expert proof, but that is not absolute. And when it falls in a common knowledge exception, then there is no need for an expert. So our first issue is when we're talking about misplacing fluid that was needed to be tested to figure out what's going on with him, and you lose it to where you have no idea where it is and you have to now do another sample. We don't need an expert to talk about how that should not happen.
Is that a disputed issue that a sample was taken and that it was lost?
Yes, there's elements of that that's disputed. There's no dispute that the additional sample was taken. It appears to be opposing counsel's argument that.
But just a second, Mr. Taylor. Let me get my question out, and then you can respond. Does opposing counsel or do the opposing parties agree that a sample was lost, or are they simply saying that an additional sample was taken?
They are saying an additional sample was taken.
Okay, so where do you determine that a sample was lost?
The appellant was told that a sample was lost, and that's why he had to have the new sample taken. And then the witness, we have also a witness in a deposition of Phyllis Williamson, was also informed that, in fact, she is the one who complained to the hospital about why it was taking so long for the result. And then she was informed, well, we're sorry, we can't find the sample. We need to take another sample. So
Okay.
we have Ms. Williamson saying that, and then Phyllis Williamson as a witness saying that as well.
Okay, thank you.
As it relates to the informed consent issue, again, informed consent in part goes towards the issue about whether or not this sample was lost and all the different things he should have been informed relating to this sample. But even more particular than that, where there is a misrepresentation or inadequate disclosure or forgery or lack of a capacity, then that gets into the realm of medical battery. Meaning if the appellant can show where there was misrepresentation or inadequate disclosure, then there's a medical battery, even if there's an informed consent form. So the problem opposing counsel has here is that according to them in their argument, if you're taking their position at face value, that the sample was never lost, then the problem they have is that once appellant was told that that is the basis why they're doing this procedure, an additional procedure is based on the lost sample, then for them to now waive an informed consent form does nothing to their argument, because that would make the informed consent procured by inadequate disclosure or misrepresentation. And once that happens, you have a medical battery and no expert is necessary at that point at all. So that is another issue that they would have that also makes there not an issue about whether or not there was an expert used on this case. Again, there's nothing that the opposing counsel has presented about it wasn't their employees involved, because one of the arguments they're making is that, well, now the argument is that, well, even if some conduct occurred that should not have, it was not necessarily their employees who did it. And in the brief, they seem to be asserting that, well, appellant is arguing this and he's arguing comparative fault, but he never raised this before, so it's waived because he's raising it now for the first time. That's not accurate. This is a de novo review, for one. So when looking at the face of the complaint and looking at all that has been filed, the court is reviewing this de novo. For two, this is not a new ground that we're raising. This is not a new issue. The issue is that we believe appellees were at fault. Appellee's argument is we're not at fault because it could have been someone else. Our response to that argument is, even if it was someone else, you're still at fault. So this is not a new issue. It's the same issue. We're just responding to their argument, which suggests that they're not at fault. And basically, we're explaining, you never alleged comparative fault. You've never filed or done anything that suggests it was anybody else other than you. So you don't get to now say it was somebody else other than you. That's it. That's the argument. There was never
Let me ask you, Mr. Tuden, before you file an action indicating comparative fault, in a healthcare case, don't you have to meet the good faith requirements?
And I'm gonna make sure you're referring to the appellees or the other side.
Yeah, well, you arguing they didn't bring in another party and argue comparative fault, but in a healthcare case, before you bring in another party arguing comparative fault, you've got to have a good faith basis to believe that this other party was negligent.
Yes, they would have to do it.
But if they don't believe that the other party was negligent, how could they bring the other party in to this action?
Well, then I guess to answer that question, if they don't believe anybody was negligent, then they're stuck with the argument they have. They don't get to deflect. In other words, if nobody was negligent, at no point do they get to argue the person who made the mistake wasn't us, because under that theory, they're arguing nobody made a mistake. So in other words, as long as they're continually arguing there was never any negligence ever, I think they're covered to answer your question. But if they start to argue with, and again,
Mr. Tootin, can you hear us?
You've frozen, Mr. Tootin.
Hello?
Mr. Tootin, can you hear us?
I can hear everyone.
Okay, all right. Well, you were frozen for several seconds there.
Okay. I was able to hear everyone. So
Okay.
I was basically answering the question to say, as long as their position is nobody was ever at fault and did anything wrong, then I think the court is correct that they're able to, they're not required to allege comparative fault or anything thereof. The problem is once the argument becomes, it wasn't us at fault, it was someone else and they didn't work for us, then that's a problem for them, because the second you're acknowledging that there was fault, then comparative fault would have been required. So to the extent they don't ever argue, which I believe they do, but to the extent they never argued anyone else was at fault, they would be covered. The second they start pointing the finger, that's where their problem occurs. And I believe to the extent they're making their arguments today and saying, court, our position is solely that nobody was responsible ever, I think they're in safe space. The second they say anything outside of that, I think they have a problem.
Well, are they saying that someone else that someone else is at fault, or are they just saying if they're at fault, they don't work for us, they're independent? They're not accusing they're not accusing these doctors of being at fault, are they? They're just saying that we're not at fault. Is that
I interpret them to be saying that they believe if someone's at fault, it's not them, but I do believe, and I'll let the court make the final decision, that would have to be comparative fault raised at that point. But I agree that I don't appear that the way I read it, I don't believe they're saying someone did do something wrong, because they're sticking with the argument there was never a sample loss. So as long as you're saying there was never a sample loss, you necessarily have to say nobody did anything wrong, because your argument falls apart at the seams the second you admit that there was something happened that should not have. And then the last issue that I raised as it relates to these affidavits that were relied on, the brief seems to suggest that they did not have to comply with Rule 56 of Civil Rules of Procedure relating to summary judgment on this, but I submit that they did. They submitted affidavits through experts who represented that they were relying on records, and they used the term generally. Not once did they designate specifically to their affidavit or to the court or to opposing counsel what specific documents they were referring to when they used the phrase records, and how those particular documents were being relied on, especially in light of the fact.
You've used your time. I'll let you go over a little bit because you froze some. But you've got your rebuttal time, and you can continue with your argument in your rebuttal time. All right, we will hear from the appellee.
May it please the court. Good morning. My name is Brooks Kostakis of the Memphis Bar, appearing on behalf of the defendant appellee, Shelby County Health Corporation, doing business as Regional One Health. The final judgment below should be affirmed in all respects. There are several grounds by which this honorable court can sustain the grant of summary judgment. And the reasons the judgment should now be affirmed are those shown in Judge Stokes' rulings from the transcript at hearing and the final order granting Regional One judgment as a matter of law. These findings and conclusions are easily ascertained from the technical record and the November 22nd, 2019 hearing transcript. And they demonstrate that summary judgment was required under de novo review. Summary judgment was properly granted essentially for three reasons. First, Judge Stokes correctly found plaintiff's lawsuit to be asserted pursuant to the Healthcare Liability Act and subject to its requirements. Second, appellant could not establish that any negligent actor was employed by Regional One, and thus GTLA immunity was not removed. And third, appellant lacked the requisite proof, expert or otherwise, to rebut Regional One's expert affidavits or to proceed on the essential elements of his various claims against the hospital. Regional One both affirmatively negated required elements of plaintiff's causes of action as pled, and furthermore, Mr. Williamson's evidence and response was found insufficient to succeed at the summary judgment stage on essential elements of negligence, including the relevant standard of care, breach, and causation. Now, accordingly, this court should sustain the grant of summary judgment to Regional 1. As to the first point, Judge Stokes correctly found that appellant's claims were brought under the Healthcare Liability Act. He stated that they involved the rendition of medical care. And as this court is no doubt well familiar by now, under the 2011 amendments, it cannot really be reasonably disputed that the claims alleged here that a health care provider or providers have caused an injury related to the provision of or failure to provide healthcare services to a person, regardless of the theory of liability. And that's regardless of what appellant would now argue on appeal. Mr. Williamson did argue at the hearing that generally expert testimony shouldn't be required as to some of his claims as he perceived them. However, he did not, as he has now on appeal for the first time, cite Osunday versus Delta Medical Center. But even if he had, it does not alter the analysis that was correctly applied by Judge Stokes. Osunday recognized that given the breadth of the statute, it quote, should not be surprising if most claims arising within a medical setting constitute a healthcare liability action. Now, because it was a healthcare liability action, appellant had the burden of proof through expert testimony on essential elements, including the recognized standard of care, breach that the defendant acted with less than ordinary reasonable care, and causation that any claimed injuries were proximately caused thereby. And so that brings us to the second point and the third points. Second, Judge Stokes correctly found that Regional 1 Health had successfully negated through its own proof any argument by plaintiff that it employed the treating physicians. As such, there was no exception to GTLA immunity. That was because plaintiff failed to show through allegations or evidence that GTLA immunity was removed. That immunity comes from statute as amended over the years at Tennessee Code Annotated 29-20-102. And it's recently been discussed by various decisions in the courts, in particular in the Bertrand and the Estate of Bell case within the past 10 or 12 years. The nature of Regional 1 status and the applicability of the GTLA should not really be at issue here. And we submit that Mr. Williamson brought nothing to the table to cast any doubt on the affirmative statements by Dr. Lord and Dr. Azuz concerning the fact that physicians with privileges at Regional 1 Health are not employees of Regional 1 Health. Therefore, there's no liability. There's no immunity is not removed, therefore, under plaintiff's theory. Regional 1 provided affidavits through Dr. Lord and Dr. Azuz indicating that physicians with privileges, such as those performing lumbar punctures or spinal taps, were not Regional 1 employees. Spinal taps are conducted, according to them, by physicians who first obtain informed consent after discussing with the patient the procedure and its risks. Mr. Williamson came forward with no evidence to otherwise support an argument that Regional 1 employees were negligent, or that any breach of the standard of care proximately injured him, or that GTLA immunity should be removed. And the Gilreath v. Chattanooga-Hamilton County Hospital Authority Erlanger case is particularly instructive on some of these bigger picture points, Your Honors. Conclusory allegations are insufficient to survive summary judgment. This case had been pending around 2 years at the time the hearing was heard. There had been ample time for discovery. There was no suggestion by Mr. Williamson that he needed additional discovery. But there was no evidence produced by plaintiff to show that any allegedly negligent act was performed by employees of Regional 1. Third, and I believe that the point that Mr. Tootin focused on the most would be that summary judgment should be affirmed because appellant failed to present required expert proof of any kind to support speculative claims for medical negligence, informed consent, or intentional or negligent infliction of emotional distress. There were no experts disclosed by Mr. Williamson on these points in response to appropriate interrogatories served under Rule 2602 They were never amended to disclose the existence of any experts favorable to his theories pursuant to Rule 2605. Mr. Williamson presented no affidavit or testimony to support liability for a breach of the relevant standard of care. And importantly, there was no affidavits or testimony submitted by Mr. Williamson to show causation, proximate causation whatsoever. Even if this court were to somehow find merit with appellant's reliance upon the common knowledge exception concerning the breach of the relevant standard of care, which it should not find merit with that argument. Even if it did, clearly expert testimony of proximate causation would be required. And an illustrative case is the Reddick versus St. Thomas Midtown Hospital case, 515 Southwest 3rd 853, Tennessee Court of Appeals 2016. However, in that case, common knowledge was found to apply to one element, but not the other. But this court need not go that route because here expert testimony was required as to the standard of care and breach as well, which Judge Stokes correctly found. Appellant's claims could not proceed for lack of proof on all of these elements. Also, the affidavits of qualified medical doctors, Dr. Lord and Dr. Azuz, submitted by Regional 1 affirmatively negated these elements. Furthermore, candidly, as elucidated at the hearing through questioning by the trial court, there was no disclosed expert testimony or opinion by plaintiff as to the actual nature and extent of plaintiff's alleged injury itself, much less causation. And Mr. Williamson's deposition testimony on this point drives home the importance of that, given his vague testimony and the lack of professional diagnoses or any real cognizable claim of harm based on the evidence that was before Judge Stokes at the time. Additionally, as to the kind of, they're separate issues, but Mr. Williamson attempts to kind of commingle them throughout this litigation of the notion of informed consent and medical battery. Those claims were also properly dismissed with prejudice because the evidence demonstrated that Mr. Williamson consented to the medical procedures, all of them performed at Regional 1, particularly as to the lumbar punctures, which are at issue. Now, in the Holt v. Alexander case cited by Mr. Williamson, that's distinguishable, and it provides no exception here to the need for expert testimony. Holt stated that under the simple inquiry test, the questions are: one, was the patient aware that the doctor was going to perform the procedure? Yes. And two, did the patient authorize performance of the procedure? And the answer here would also be yes, and that's documented in the record. Well, as such, because the answer is yes to both of those questions, the claim cannot be one for medical battery, but it's one of informed consent. And that fails based on Regional 1's affirmative evidence and for lack of testimony under Rye. And in Blanchard, the Tennessee Supreme Court explained that in an informed consent case, expert testimony is necessary because a court must consider the nature of the medical treatment, the extent of risks involved, and the applicable standard of care in determining whether the information provided to the patient was adequate. There's no misrepresentation that would exclude Mr. Williamson's claims from the need for expert testimony based on the evidence of record. Furthermore, appellant alleged no such misrepresentation in his pleadings, even as they were amended. And even under Holt, a claim for medical battery can only be established if it's shown that a physician intentionally or recklessly misrepresented a material fact in order to obtain the patient's signature on the consent form, thus vitiating the patient's consent. There is no such evidence here, and that no material fact exists. As to a claim for infliction of emotional distress, Mr. Williamson likewise produced no evidence that any Regional 1 employee intentionally or negligently caused him to suffer severe emotional distress or a serious mental injury. And that's briefed in the summary judgment memoranda statement of facts. And it's evident as well through Mr. Williamson's own testimony at his deposition. Finally, punitive damages clearly could not have existed here because of the reasons I've already cited. There's no liability. There can be no punitive damages. In any event, they're unrecoverable under the GTLA. And in any event, this claim can't survive the analysis above. And Regional 1 was entitled to dismissal based on a lack of required evidence of any purported egregious conduct. For these reasons, the court should affirm the final order and judgment granting Regional 1 summary judgment on all claims asserted by appellant in this action. Thank you.
All right. Thank you, counsel. Mr. Tootin, we'll hear from you, sir, in rebuttal.
Yes, the statements opposing counsel made, it's easy to say there's no evidence if we're going to just basically ignore appellant's evidence. Yes, if we ignore appellant's evidence, then there would be no evidence. But for the fact there's evidence. For example, to say that there was no material misrepresentation which would cause an issue of medical battery is not accurate. According to opposing counsel, the argument is that there was never a lost sample. According to our witness and appellant, he was told that the sole reason he was having another procedure done was because of a lost sample. If that is not a material fact or a material misrepresentation, then I don't know what is. As it relates to the harm that was caused to him, which it seemed to be suggested that there was no harm or damages referenced. That would be for the jury to determine, but one of the things I pointed out at the hearing, which is in the transcript, is at a minimum, the fact that Mr. Williamson had to pay for an extra procedure that would not have been done had he known the real basis for what was going on versus the hospital being responsible for paying it. At a bare minimum is a form of damages financially. So to say that there's no damages would be a stretch. And for two, that would be a jury question anyway, once we're talking about damages. This argument about the physicians not being employees, so there's no issue there, misses the issue, whether accidentally or intentionally. The issue is not the physician because there is no argument about the spinal tap at this point being performed negligently. The issue is that the sample was lost. The sample being lost is not a physician's job. That would fall under the hospital and their employees. After the physician completed the job, obtained the sample, the argument is the sample was lost. That argument does not appear to be addressed at all by opposing counsel. Again, this argument about the affidavit being sufficient, again, the rule is extremely clear. If we're going to rely on an expert testimony for motion for summary judgment relating to an affidavit, they are required to articulate to us what documents and records they're using to form their opinion. They are not simply able to say medical records when in this case, Mr. Williamson was seen on several dates in several places and has multiple records. You don't get to use an umbrella argument of when reviewing the record without fleshing out which records were reviewed. So I stand by the fact that that is extreme. The rule is extremely clear on that. And if I'm wrong, I'm sure the court will tell me I'm wrong. But the rule is very clear. An expert does not get to use that generic phrase without fleshing out what specifically what specific records they're relying on. And then as it relates, again, going back to this lost sample, there's been no proof to this day by Regional 1 as to their employees not being responsible for handling the spinal tap fluid that needed to be tested. They're focusing on, well, we didn't employ the doctor, while ignoring the issue of, well, once the spinal tap fluid was passed on to their employees, it was lost. And that's not addressed at all. They don't even allege anything that can infer that their employees didn't have any contact with it. So to say appellant didn't provide any proof on that issue, it was Regional 1's burden on the motion for summary judgment to prove that their employees never handled the sample for it to be lost. They never raised that issue. They simply focused on the fact, well, we didn't employ the doctor. And again, to the argument about the Healthcare Liability Act, we understand when dealing with a medical provider, you have to file, you look at the healthcare liability statute. I don't know if that's not in dispute. What we're saying is, once we see that there's a ground that you can go forward on that deals with common knowledge negligence, you don't need an expert. That's the sole argument, is that an expert is not necessary. Not that
how do you prove your damages, Mr. Tootin?
Well, I think the easiest way.
Let's assume, for the sake of the argument, that it was lost, what's your proof that that somehow exacerbated his condition and that he has damages? How do you prove that?
Well, for negligence on that common law issue, we don't have to prove exacerbation. If nothing else, we just pull up the medical bill and say he was required to pay now for this additional surgery that they made him foot the bill for their mistake. I mean, if nothing else, I mean, at a bare minimum, we can show the damage there. They say, look at this bill. This is what his bill would have been had they not made the mistake. They made the mistake, told him that he now had to do this additional for surgery, and then they charged him for it. That's a mistake that they should have put the bill on. We can show a financial damage as a starting point. I mean, at a bare minimum, we could show that. I mean, that's in the printout of the record. And that's again why we that's why that's it, and that's in the further. That's why it would be a common negligence on that argument as opposed to one where an expert would be needed. Thank you. That's all.
Thank you. Thank you, gentlemen. We appreciate your argument. We will attempt to get you an opinion at the earliest possible time. Mr. Hebner, if nothing else, we'll be in recess till the call in the next case.
This honorable court is now in recess until 11 a.m.